Number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, as you said.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's
I
office.
have asked, I've went to records and it is not available.
Okay, well, we can deal with that later. This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of the traffic citation that was issued on November 4th, 2020?
Yes, yes.
Okay, you are charged with one count of stopping after, or failing to stop after an accident or leaving the scene of crash or accident. A violation of section 335.12A1 of the Conneaut City Ordinances. If you're convicted of this offense, it's first degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that? Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney, you don't know the legal processes. So I
do have that right though, right?
You sure do.
Right out of the gate, the tone is set. New judge, new courtroom, and a defendant ready to go pro see like it's a casual life hack. He sounds steady, maybe even a little self-assured, as the case is called and the formalities begin. But court isn't social media, and it's definitely not a DIY tutorial. The judge is calm, direct, and methodical. You can already sense this won't be a playground for smart remarks. This is structured, procedural, and unforgiving to anyone who mistakes confidence for competence.
Do you read and write English for the record? Provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign in date at the bottom. Court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Colton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the ticket has you at West Main?
Yes.
What's the apartment number?
37.
37 in Conneaut. How long have you lived there? 4 years? Let's see, Mr. Colton has no prior criminal history in this court. His last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pre-trial conference in the near future. You're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of County, have $5,000 if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any questions for me?
The judge walks him carefully through his rights and plea options, giving him every opportunity to understand what's at stake. Instead of focusing on the gravity of the charge, he pivots to a crash report issue. It's a subtle but telling move, already distracted by discovery before even entering a plea. The judge keeps it simple. Plead first, sort paperwork later. This is Courtroom, sequencing 101. He says, "Yes, sir," but you can hear that he's already gearing up for a procedural battle he doesn't fully understand.
I am not your legal advisor. So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office. Okay?
Now the stakes are laid out clearly. First-degree misdemeanor, up to 6 months in jail. Hefty fines, restitution, and license suspension. This isn't a parking ticket. The judge methodically explains every possible consequence, ensuring there's no confusion later. When he pleads not guilty, the court accepts it without drama. But the real turning point is the attorney question. He declines representation without hesitation. That decision shifts the entire energy of the room. From here on out, every misstep belongs to him alone.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting railroaded.
The judge doesn't sugarcoat it. Representing yourself in a criminal matter isn't bold. It's risky. The analogy about having the right to do something but not necessarily the wisdom to do it lands hard. Still, he insists. The waiver of counsel is signed. This is the moment accountability locks in. No fallback, no blame shifting. The court confirms he can read and write English, ensuring the waiver stands solid. The judge gives him autonomy, but also the full weight of responsibility that comes with it.
I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton. Okay. Do you have any other noises you want to make before you leave this courtroom? Then get out of here without making a noise.
Yes, sir.
Bond is addressed with measured fairness. No criminal history in this court, no flight risk, last traffic issue over a decade ago. The judge sets a personal recognizance bond at $5,000. It's reasonable and balanced. He's treated like someone capable of following instructions. The court outlines exactly what happens next. Get your hearing date, show up, or face consequences. Everything is clear. The system is functioning as designed, structured, transparent, predictable. At this stage, things could have ended smoothly.